Yes, Ankita, go ahead.
Okay. Welcome everyone. My name is Ankita Srivastava. I'm the Research Associate and Content Manager at Legal Desire. I'll be the MC for this session. Topic for the session is New Dimensions in IPR, Fashion and Arts. To give an introduction of the topic, the foundation of international intellectual property protections was created in the 19th century at various congresses in Vienna and the rest of Europe. The protection of industrial property was created in Paris Convention in the year 1883. Patents, trademarks, and industrial designs were the three main properties that were granted protection in this convention. In 1998, India became a member of the Paris Convention. Today, as technology explores newer dimensions and uncharted paths, IPR is assuming conducive forms to encourage innovation and knowledge sharing in a fiercely competitive network. In this background, today's session is one effort to explore and discuss new dimensions of IPR, namely fashion and art. Our first speaker for the session is Maria Vathis, who will speak about fashion and litigation in the United States. She will also cover how COVID-19 has affected fashion law industry in the United States. She is the former president, Federal Bar Association of Counsel at Bryan Cave Leighton Paisner LLP. She also advises corporate clients on statutory regulations and compliance. She represents throughout the United States and in Europe. She is a frequent speaker at fashion law conferences in cities like Chicago, New York, Paris, France. And as of October 1st, 2018, Maria has been the national president of the Federal Bar Association. Now you can go ahead with your presentation.
Hi everyone, my name is Maria Vathis. I'm an attorney in the United States. I work at Bryan Cave Leighton Paisner LLP in the Chicago, Illinois office, and you've actually got the Chicago nighttime skyline behind me. It's my pleasure to join you today to talk about fashion law in the United States. Now, when you hear fashion law, hi everyone, my name is Maria Vathis. I'm an attorney in the United States. I work at Bryan Cave Leighton Paisner LLP in the Chicago, Illinois office, and you've actually got the Chicago nighttime skyline behind me. It's my pleasure to join you today to talk about fashion law in the United States. Now, when you hear fashion law, you automatically think of intellectual property. So we'll spend some time providing a brief overview of trademarks, copyrights, and design patents. Then we'll talk about litigation in the United States, and in particular class actions and how they've touched the fashion industry. And because we're in the middle of a global pandemic, we'll also talk about how COVID-19 has impacted the fashion industry. So with that, I'll share my slides and we'll get started. Okay, so we'll jump right in with trademarks. So in a nutshell, a trademark is a sign or symbol that indicates a company. So it can be like the Colgate toothpaste logo or the Lacoste crocodile. It's any kind of signifier that a company uses to distinguish its goods or services from other companies. It can be words, symbols, designs, sounds, smells, trade dress. A trademark must be attached to particular goods or services, and it must be used in connection with goods or services in commerce. Rights are granted to the first party to use the mark in commerce. Trademarks enable a consumer to figure out who made a good or if a product comes from a particular manufacturer. While trademarks function primarily as a source identifier, they provide a number of ancillary benefits. So consumers who associate a particular brand with high quality will be more likely to seek out that brand when searching for goods. Companies can build up goodwill in their brand, which is a highly valuable intangible asset. So we have an example here to look at. It's the same mark may be used by different companies if it's used on such different products or services or marketed to different consumers, such that there would be no likelihood of confusion, which is the key phrase, as to what the source of the product or service is. So here on the left, we have Boss used on jewelry. This is a watch from Hugo Boss Trade. And on the right, we have Boss used for catering restaurant services by Boss Shepherds LLC. So it's the same exact mark, but it's used on very different products and services, and it's targeted to different consumers. As a result, there would be no likelihood of confusion that a consumer purchasing a Boss watch would think it's associated with restaurant catering services. Sounds and smells can also be source identifiers, and I have an example for you here. These are chimes of the network NBC. So listeners who hear the musical notes G, E, and C associate that with NBC. Coconut scents also for fit-flop shops are associated with that retail store. They feature sandals and flip-flop sandals and related accessories like beach balls and keychains. And the mark consists of a coconut scent or fragrance, which the owner of the mark feels fits with the company's laid-back vibe. Trademarks are categorized on a continuum from generic, which can never gain protection, to fanciful or arbitrary, which is inherently distinctive. Because trademarks act as a source identifier, they must be sufficiently distinctive so that consumers can identify one brand over another. So generic marks, such as the common name of a product, can never gain trademark protection. And what is generic depends on many factors, such as culture and location. A mark is descriptive if it provides information about attributes of the product or service or describes the product or service itself. Purely descriptive marks cannot obtain trademark protection unless they are capable of acquiring distinctiveness by such continuous and exclusive use that consumers come to think of it as a distinct source identifier, separate and apart from the mere descriptiveness of the words. Suggestive marks are ones that a consumer must make an imaginative leap to associate with the type of good or service. So here, for example, we have Top Men, which is clothing for men. That's a suggestive mark. Fanciful marks are made up words, and arbitrary marks are generally actual words that are used in an unexpected context. So here we've got Lululemon for yoga apparel or arbitrary. An example of that would be Express for clothing. Another example would be Apple for computers. Trademarks must be sufficiently distinctive so that consumers can identify one brand over another. The same mark may be sufficiently distinctive to act as a source identifier for certain goods, while completely descriptive or even generic for other types of goods. So in this example, Polo Sport, owned by Polo Ralph Lauren, here Polo is not descriptive of the clothing. However, the word sport is likely descriptive because it provides information about attributes of the goods, clothing that would be used while playing a sport. Polo Ralph Lauren disclaimed sport from the mark for this reason. This means that while sport is technically still part of the registration, the owner has no exclusive rights to it because it is descriptive. You can compare that with Polo Sport on the right, which is wholly descriptive or even generic, meaning equestrian games or polo games. This mark likely could not be registered at all. Use of personal names as source identifiers is especially prominent in the fashion industry, where marks are often the name of a particular designer. So we have Michael Kors, Calvin Klein, Ralph Lauren. Personal names generally cannot be trademarked unless consumers associate the name with a particular good or service. So here we have an example, Michael Kors, for retail store services in the fields of clothing, jewelry, and clothing accessories. In order to be trademarked, sufficient advertising and marketing must be done so that the name becomes associated with the brand. Now, if the designer leaves the firm, they may not have full rights to use their name. So designers need to be careful to negotiate the rights to their name with their fashion companies. Trade dress is a special category of trademarks. Trade dress protects a product's design or particular attributes. So examples include Christian Louboutin red soles. I have an example here. So here's a Christian Louboutin shoe with its red sole. Also the Hermès, Birkin, and Kelly bags. Trade dress is very helpful for big brands that are easily identifiable, and it applies only to aesthetic rather than functional attributes. Louboutin has been painting the outsoles of his women's high-heeled shoes with red lacquer gloss since 1992. He registered the red lacquer outsole as a trademark with the US Patent Office in 2008. There's a famous case that involves Louboutin and Yves Saint Laurent. It's the Second Circuit case from 2012. In this case, Louboutin marketed the shoe with its distinct color, the lacquered Chinese red on the outsole of the shoe. YSL made a shoe with a similar color, but the entire shoe was red. So Louboutin claimed that the YSL shoe infringed his trademark rights to use this distinctive red on the shoe. The Second Circuit disagreed with the lower court and basically determined that it was an error to determine that a single color can never serve as a trademark in the fashion industry. The trademark of the red sole had acquired limited secondary meaning as a distinctive symbol that identified the Louboutin brand. The court did not address whether YSL's use of a red outsole risks consumer confusion or whether the Louboutin mark as modified is functional. So this case was really all about the contrast. So the red with the black, that's protected. But YSL was able to make a shoe that was all red, meaning both the sole and the shoe itself are red. Let's talk a little bit about trademark registration and that process. An applicant must submit an application with the proposed mark, the goods or services that the mark is used in connection with, and a specimen showing the use of the mark in commerce in connection with those goods or services. After the application is received, the applications undergo an initial examination, typically within 3 or 4 months. The trademark examiner will search for other pre-existing marks to determine if the mark is valid, not descriptive or generic, and whether the applied for mark would cause a likelihood of confusion with pre-existing marks. So the applicant has opportunities to submit arguments against any rejection. Intent to use applications. So an applicant who has a bona fide intent to use a mark in the future can also file an intent to use application. The application will not register until the mark is actually used. After registration, the use of the R in a circle can be used next to a mark, and before registration, you can use TM or SM. Why do this? What are the benefits of federal trademark registration? So owners of a valid mark have legal rights even if the mark is not registered under common law, but those rights are limited to the geographic area where the mark is used in commerce. Federal registration provides more protection. So under the Lanham Act, federal registration provides rights nationwide and creates the legal presumption of validity of the mark. Federal registration constitutes constructive notice, and it gives the presumption of validity. So after 5 years of continuous use with no adverse lawsuits or oppositions, the mark can become incontestable, which means that it severely restricts any grounds for finding that mark invalid. Trademarks typically do not protect an entire garment or accessory, but you can protect the logo or the label. It is still a relatively strong form of protection, so it is highly advisable to go through the registration process, even though there is some protection under common law without registration. Trademarks are valuable for big brands. For small brands, when they're copied, copiers tend to copy everything except the mark since it's unknown and not as valuable. Trademarks are more expensive than copyrights, but less expensive than patents, and they're frequently used in the fashion industry. You would need a separate registration per category. For example, clothing, footwear, accessories, jewelry, perfume, those would all be separate, and words are easier to trademark than symbols. I'm providing this slide about the value of trademarks because I think it just shows how important it can be for big brands. This information is a little bit outdated, but I think it does provide just some eye-opening information as to how valuable trademarks can be, especially for these big brands. Okay, moving on. What is a copyright? So the basic rule of what is protectable under copyright is that it has to be original. Original works of authorship fixed in any tangible medium of expression. And some examples are below here. Literary works, musical works, dramatic works, pantomimes and choreographic works, pictorial, graphic, and sculptural works, motion pictures, sound recordings, and architectural works. In the fashion world, it usually applies to jewelry since it is decorative and not functional, unlike clothing. And it also applies to designs like fabric weaves, lace, fabric prints. We discussed trademark registration, so now let's talk a little bit about copyright registration. It's easier and less expensive than getting a trademark. So like trademarks, copyright protection exists even without registration, but there are benefits to registration, which means that you get more damages should you run into any problems. Unlike trademarks and patents, copyright registration usually only requires a deposit of acceptable copies of the work with the Library of Congress. So it's pretty easy to do and highly recommended. Okay, design patents. Utility patents versus design patents. Utility patents grant the inventor a limited monopoly over new functional innovations. The term is 20 years from filing. Design patents grant a limited monopoly over the original ornamental design of the article of manufacture, and the term is 15 years from the issuance of the product. It's quite expensive to get a patent, and it can take years to issue. Examples of things that design patents usually apply to include clasps, zippers, Velcro, Spanx, athletic shoes. For example, Nike has many design patents. Design patents offer protection based only on the picture designs in the patent. And here's an example of a design patent for athletic pants. I also want to spend a little time talking about brand licensing. Trademarks, brand recognition, and goodwill associated with its brands are often the most valuable assets that a company has, especially for large brands. Licensing allows trademark owners to capitalize on their brand and increase market penetration by taking advantage of the licensee's infrastructure and resources. Celebrities often license their name to fashion lines and other products. For example, singer Lady Gaga licensed her name to Coty Inc. for perfume several years ago. The owner of a mark has a duty to police the use of its mark. A trademark may be declared abandoned if an owner does not control the nature and quality of its goods or services. A licensor has the same duty to maintain adequate quality control over the licensee's activities. If the licensor does not monitor and enforce the quality of the goods being offered by the licensee, the licensed mark may lose its significance as a mark and be deemed abandoned. Negotiating a license. In this situation, the licensor retains ownership over the mark, but enters into an agreement where the licensee is allowed to manufacture and distribute goods under the mark, subject to oversight and control by the licensor. Negotiating a license agreement can be difficult, and there are some considerations that must be, considered before finalizing any deal. So, rights retained by the licensor. A licensor is responsible for policing its own mark and should carefully negotiate the specific rights that it's granting to the licensee, including the specific rights that it's retaining. The schedule of license marks, assignability, change of control. So on the other side, licensees may want to negotiate a change of control provision whereby they have the right to terminate the agreement if the licensor's rights and assets are sold or transferred to another company. So the agreement should contain this language. Indemnification, where the licensee agrees to indemnify, hold harmless, and defend the licensor against any lawsuits. The right to sue, term and termination for when the license will terminate, auto renewal language, and also royalties, which is how the licensor is going to be compensated for licensing its brand. Okay, now we're going to move on to our next topic, which is litigation in the United States, and we're going to talk a little bit about the types of litigation that could impact the fashion industry. Now, it really could be anything, but I'm just going to talk about the most likely litigation scenarios here. So trademark infringement, counterfeit products, contract dispute, class actions, employment disputes, and insurance in some instances. Common types of class action lawsuits in the fashion industry: purely statutory violations. For example, the Telephone Consumer Protection Act. I've been handling those types of those types of class actions involving statutory violations since 2003. False advertising and marketing of products, wage-related claims, security law violations, and racial discrimination claims. This is an example of a TCPA lawsuit against a retailer. So the Telephone Consumer Protection Act prohibits the sending of unsolicited commercial faxes, unsolicited phone calls, telemarketing calls in certain instances, and text messages. And the fines for these types of alleged violations are pretty steep. So it's $500 per violation or $1,500 if you knowingly violate the statute. So the damages can accrue very quickly, and often they can be quite large. One example here is Melito versus American Eagle Outfitters. This was a Southern District of New York case from 2014. This case involved text messages sent to cell phones by American Eagle without the requisite consent under the statute. The court conditionally certified a class for settlement and approved a class action settlement involving a common fund in the amount of $14,500,000 US. Fair and Accurate Credit Transactions Act. This is another statute. This statute amended the Fair Credit Reporting Act to add identity theft protection. It, on a per consumer basis, allows actual damages plus reasonable attorney's fees and costs, and also statutory damages and punitive damages. So one example here, Moransky versus Godiva Chocolatier. It's an 11th Circuit case from 2018. A customer brought a putative class action alleging that Godiva's printing of customer credit card numbers on receipts exposed them to an elevated risk of identity theft. The parties entered into a class-wide settlement with a settlement fund of $6.3 million. So I just want to illustrate just how big some of these awards can be and why it's important to be aware of these statutes. Another type of class action that a retailer could face are, false advertising claims. For example, Span versus JCPenney Corporation. JCPenney is a department store. This was a case from the Central District of California in 2016. The plaintiff brought a class action alleging that JCPenney falsely advertised original and sale prices in violation of several California statutes, and the case settled on a class-wide basis. JCPenney established a $50 million settlement fund. Wage claims as well. So there are several here, but I'll just talk about the first one, Walmart stores versus Dukes. This was a Supreme Court case from 2011. The Supreme Court of the United States determined that a class could not be certified because the commonality requirement here could not be satisfied, which is an element for class actions. Female employees brought a Title VII action alleging sex discrimination and seeking injunctive and declaratory relief, back pay, and punitive damages. The class was comprised of about 1.5 million current and former employees who alleged that the discretion exercised by local supervisors over pay and promotion matters violated Title VII by discriminating against women. Racial discrimination. So this is one example. Sampino versus Versace USA. It's a Northern District of California case in 2016. A former employee filed suit against Versace alleging unfair business practices, racial discrimination, and wrongful termination in connection with the design house's alleged use of a secret black code to alert staff and security when a black shopper was in the store. According to the class action plaintiff, he was discriminated against and fired for being of mixed race after working 2 weeks at the Versace outlet in Pleasanton, California. On January 23, 2019, the court granted the order preliminarily approving a class-wide settlement in the amount of $300,000. Okay, so like I said, because we're in the middle of a global pandemic, I think it's important to talk a little bit about how the fashion industry has been impacted by the virus. And we'll start by talking about what I'd like to spend a little time just telling you what I've been doing since the pandemic hit. We've been sheltering in place or staying at home here in Chicago and actually most of the United States for many, many weeks. Here in Chicago, we're on our 7th week of working from home. I have not been in my office. I've basically just been working from this room here for 7 weeks, and I've been working very long hours. I've been quite busy. So several of the questions that I've been asked to address include contract disputes arising out of the virus and the inability to perform under the contract, telemarketing compliance issues, insurance coverage. We're also starting to now turn to address concerns that retailers are having with reopening their stores. For retailers in the United States and its territories like Puerto Rico, each state has its own date as well as guidelines for reopening the stores to the public. So we're monitoring these regulations for each state and territory on a weekly basis, along with requirements for employees and consumers to keep them safe, like wearing masks, staying 6 feet apart from each other. And we're doing that so that we can properly advise our retail clients. So in the fashion industry, an example of a contract dispute might involve a supplier that can't fulfill its contract. Force majeure is a contractual defense that we keep hearing about in connection with COVID-19. It may relieve a party from liability due to the inability to perform under the contract caused by unforeseen circumstances. If the contract at issue does not contain force majeure language, there are common law doctrines for the defense of non-performance, like frustration of purpose, impracticability, or impossibility. Insurance coverage issues include first-party property concerns, commercial general liability coverage, directors and officers liability. So we can expect to see claims submitted to many insurers for coverage. There are policy exclusions that may apply depending on the language, and we're already seeing lawsuits brought by some business owners in Chicago against their insurance companies after their claims for losses tied to the pandemic and after those claims were denied. So these lawsuits claim that losses resulting from the pandemic should be covered under mainly business interruption insurance, and usually that's found in a property insurance policy. But many insurance policies exclude coverage for losses caused by viruses. I worked actually in London, in the London insurance market for a short amount of time, and spent a lot of my career addressing, insurance defense litigation, insurance coverage issues. So, this is something that I can tell you it's just going to depend on the various language in the insurance policy. And the same goes for contracts too. It really just depends on the specific language in the contract. But we're just seeing a lot of these questions coming up as a result of the virus and the fact that it's caused a lot of disruption for businesses and frankly for everyone. Many insurance policies exclude coverage for losses caused by viruses, but insurers may come back with the argument that insurers could have purchased separate coverage for pandemic coverage in some cases. I've also seen some shareholder securities fraud cases being filed in connection with COVID-19, and potentially CEOs or CEOs are vulnerable under directors and officers liability claims in connection with management of companies. For example, In one lawsuit, there's an allegation that the company was using misleading sales tactics relating to the COVID-19 outbreak. Another putative class action was filed by a shareholder and its CEO for violating securities laws in connection with statements made to the public that it had developed a vaccine for COVID-19, which allegedly was not true. So it's sort of unique to see potential claims under directors and officers liability policies. We didn't see these types of claims filed in connection with other outbreaks like SARS or MERS. So this is definitely going to be an interesting thing to watch, and it's unique. COVID-19 has impacted the fashion industry. So according to Women's Wear Daily, fashion stocks plummeted. There have been Fashion Week disruptions. Milan Fashion Week was affected in late February 2019. Some designers changed the format of their shows. I've read that some fashion houses have canceled their shows going into 2021. Other events are going virtual. So, you know, it's already impacted a lot of different aspects of this industry. There's a mass closing of retail stores, beauty, health, and fitness chains have closed. And from my own research, I've seen a lot of pay decrease for top executives. A lot of them have done it voluntarily. Many employees have been furloughed in order for the brand to survive. So we're seeing, you know, widespread change as a result of COVID-19. I spoke to Marie P. Anderson. She's a model industry expert, and she has Boss Babe Models as her company. She told me that models are being impacted with respect to bookings. There are fewer of them, right? Or they're just different because you can't meet people in person right now. Photo shoots are going to change or have changed because of the same social distancing requirements. Garments are being shipped to models right now, and models are, you know, they don't have hair designers or, you know, makeup artists at their disposal. So that's going to potentially affect how photos are being taken. And we can see that, you know, in the future, there's probably going to be different setups in studios to make sure that precautions are taken to protect people. So, you know, there's going to be, again, like I said, widespread change as a result of this virus. Okay, so brands that are looking to open again, it's going to be very important for these brands to focus on brand strength, financial endurance, creative flexibility, and operational agility. And I found this in an article in Women's Wear Daily, which I have below, and I think these things are all very important. Sustainability, making sure that, you know, the customers and its employees are kept safe, being flexible in that if, you know, more sales are happening online, making use of technology like 3D technology, for example. All of these things are going to be very important to easing into reopening after, or I guess, reopening the actual brick and mortar stores to the public. And as a lawyer, I had to add my own here, adherence to laws and relevant guidelines. I think that's going to be very, very important for retailers in the coming months as they reopen their stores. So what's next? A lot of designers are designing masks. So here on the left, I have Christos Tsatsiris. He is a designer here in the Chicago area. He designs furs, and he has this fur mask here. Allison Olivia is showing a mask and gloves on social media. And I want to end on a positive note. So I know that COVID-19 has caused fear and losses. I'm truly sorry for those that have suffered as a result of the virus. But one thing that has come out of this is we're coming together, and we're seeing the good side of fashion and things that designers are doing to help people. So this is designer Lauren Line. She's a Chicago-based designer. She is making masks, and from those proceeds, she's making masks and then donating those masks to nurses and to people in the medical field who need those masks for protection. protection. And we also have here Chicago-based designer Richard
Thank you, ma'am,
Dayhoff.
for gracing us with such
He
useful
participated.
information. Our second speaker for the session is Shreya Gupta, who will talk about fashion law industry in India. Hi, thank you, Ankita, for inviting me. Before starting with anything else, I just want to give you a very brief about what this word fashion law means. Fashion law, also known as apparel law, is an up and coming legal field that covers concerns surrounding the fashion business as well as the industry. Starting from the conception of an apparel to the protection of the brand, everything revolves around the fashion and a fashion lawyer. Clientele which a fashion lawyer has is fashion designers, manufacturers, distributors, retailers, fashion houses, modeling agencies, and photographers. All these people need the consultants of a fashion lawyer in their business from step one till the last step. Primarily, fashion law relates to intellectual property rights, that is copyright, trademarks, contracts, commercial transactions, including both domestic and international. We can't forget the employment and labor laws and the custom laws. Some shops and labels have their own in-house counsel teams, whereas some outsource it from the legal firms. My main concern for today's session is that do we really think that the fashion law or the fashion lawyer is an important role in a designer's life right now? I think it's a big thumbs up because the common man doesn't know the need what a fashion designer needs. But fashion houses and designers are really facing unique challenges specific to the industry. They require attorneys who can understand the advantages and disadvantages of the various types of intellectual property protection, particularly in the nature of the fashion industry. Moreover, the increased availability of counterfeit goods, the knockoffs of the designer bags, accessories, clothing are the threat for the so-called copyright trolls. We come across so many counterfeited products in and around in our life. Small vendors, local vendors, they are getting so many counterfeited products, the design, copied designs from the designers, without even caring what harm are they providing, are they giving to the designers. So let's just give a very small brief about what it is all about. Fashion industry deals with the unusual international supply chain issues also with a very specific employment law concerning, such as the issues of minors working in the fashion modeling or as a minor labor working in the overseas factories or the factories around us. Consequently, while fashion law is fairly new specialty area of the practice, it is gaining momentum and sure to a major focus in years to come. Let me talk about few elements of a fashion law. What all things or duties that the fashion lawyer has to give or to provide. Starting with intellectual property, that includes trademarks, trade dress, trade secrets, copyrights, patents, design patents, and utility patents, design piracy, counterfeiting, and fashion licensing. These are few headings which comes under intellectual property. I am just going to give you a very brief about all this thing. I'm not going to go into it because it's a very, very huge topic to talk about. Business and commercial matters, including entrepreneurship, finance, contracts, mergers and acquisitions, marketing, advertising, and retail licensing, import, exports, transport of business, expansion, and brand protection, fashion law litigation, consumer protection, antitrust law and competition, and the labor laws. In the era of 2020, where everything revolves around the technology around us, we can't forget to connect fashion, fashion law, and the technology together. So let's just go through the massive disruption of the fashion industry, which is being caused by the technology. The advent and the growth of additive manufacturing, that is the 3D printing, is the biggest disruption that the fashion industry has ever experienced. It's turning both the industry and the fashion law inside out. With the 3D printing wearables entering the market, a whole lot of bunch of new legal issues are emerging and affecting traditional fashion law practices areas. I just want to give you a very small brief about what all examples can come under the fashion law technology, that is the 3D printing. When we talk about the labor and the employment law, 3D printing will eliminate many traditional fashion manufacturing jobs while at the same time create entirely new ones, including workers who design and prepare it for 3D printing, people who transform and other raw materials into 3D printables, supervisors and manufacturers, software designers who code clothing designs. Now, the biggest question is here, decisions will have to be made regarding whether employees or independent contractors will fill these new roles, except an increase in industry labor and employment lawsuits. Coming over to intellectual property, I want to ask just few questions. If a purchaser customizes a piece of clothing from a company's website, let's say I own a website and you are my customer. You want me to customize a dress, you are giving me the design. Later on, if something happens, then who owns the design? Will it be me or you? Again, if a customer describes a design to a designer who then creates the software, who owns the design? Third, if a customized clothing arrives and doesn't fit, who is liable? If let's say I have given my customized measurements on any random website which is running its product online, and later on it doesn't fit to me, who will I blame it? The software designer, the manufacturer, supplier, or the end user, the third party? Who is responsible and for what? What is the reason behind it? So can a customer also obtain a refund for a customized product? That will be difficult. So these are the few questions which I think, and I think it's a very major concern in today's time. And these are the examples which fashion technology opens up wholly new legal vistas and opportunity for the legal attorneys. Talking about the duties and obligations of a fashion lawyer can counsel clients on legal concerns facing the industries of fashion, textile, footwear, jewelry, cosmetics, as well as the other sectors involved around. This also includes legal concerns for merchandising, licensing, distribution, intellectual property, agreements on franchising, employment, as well as issues on labor relations. It also focuses on the sustainability, safety, concerns on consumer protection. Even the fashion lawyer has to play an important role when it comes to corporate finance with fashion, real estate again with fashion, business laws with fashion. All these things also come into play. Fashion lawyers till now have been given a lot of duties to perform. And most importantly, out of all these is the major one, the drafting contracts, negotiating agreements, litigating trademark and copyright, as well as other issues of intellectual property. Fashion lawyers are responsible for creating as well as dissolving business units and advising on developing and protecting their brands. Starting from the manufacturing of the product, the designing of it, the manufacturing, the production, everything is associated with the fashion lawyer. They need to advise them on every particular topic. And talking in the growth of the fashion law is rapidly increasing as the designs, copied designs can be seen in and around us at a very common state. Let's talk about the Chandni Chowk. Everyone knows it's a hub where we can find all the designer copied dresses at a very affordable prices. It somehow do satisfy the needs of the customer, but nobody around them. We don't even understand what harm are we creating to the fashion designers. The designers who are trying to protect their designs, who have worked for it so many hours, the labor who is working behind the scenes. So we are somehow destroying their employment as well. People who want to break into the fashion law field, they can finish their course and programs in fashion law or business laws and finance, intellectual property, international trade, consumer culture, government regulations. They can give these courses can give you a foundation that may increase your likelihood of finding employment in the field. Also, if you voluntarily want to help and offer your legal services in the fashion community, that is again a pro bono in order to approach to acquire contacts as well as related experience. In India, very few law firms are specializing in this area right now, and especially law firms who are concerned with the intellectual property rights do focus on this issue. Career opportunities in law firms. There are a growing number of law firms and consulting firms who are focusing on the fashion law. They giving the increasing in demand for transactional, contractual, and litigation services. Fashion houses They are valuing the in-house counsel so that they can give their multidisciplinary expertise to their clients on understanding the complex legal issues at the national, transactional, and international level. Fashion designers also seek consultation in protecting their designs in clothes, accessories such as trademarks, copyright, and also seeks in getting their work patented at times. Textile, jewelry, and high-tech industries. These industries and their products involve several steps and a wide range of activities, often performed by different suppliers. The partners that may entail intricate contract negotiations, shared responsibilities for transportation and distribution, also protecting their copyrights and patent rights. In the end, I just want to give you a very small illustration about the very infamous case of Rana Plaza incident, which killed over 1,100 garment workers in Bangladesh. It clearly shows that how important this fashion law is for the people who are working in this industry, so that even they can protect their rights. In this case, the main highlights were that the poor labor enforcement by the global fashion leaders such as Zara and H&M, they got harmed. They harmed the employment and the in the life of the laborers who were working behind these scenes. Very famous companies like Zara, H&M, PVH Corp, which includes Calvin Klein, Tommy Hilfiger, they have their factories in the Bangladesh working for it. From there only they supply all their products. So this is very important for everyone to be aware about legal issues facing the fashion industries, ranging from merchandising, distribution, and franchising agreements to intellectual property and labor laws. That's all, guys, for fashion law and what all things around us. I hope I have cleared what this term means, and we can get back soon on this topic again. Thank you.
Thank you, ma'am, for insightful information. Our third speaker for the day is Subhash Bhutoria, who will talk about fashion and art. He's a lawyer practicing intellectual property rights and art law for over a decade. He's also the arbitrator at Court of Arbitration for Art. In 2017, he joined Creda Legal as a partner and founded the intellectual property rights and art law practice. Besides being a lawyer to a diverse clientele, he's also associated with a handful of India's leading galleries, artists, and photographers, helping them with commercial transactions, dispute resolution, and intellectual property protection. We welcome you, sir. You can proceed with your presentation.
Thank you, Ankita. I hope you and everyone at Legal Desire and all our viewers are doing well in these difficult times. We'll soon be out of this whole pandemic and the lockdown, and I hope we'll maintain our social distancing even thereafter, which is very important. Well, it's very interesting. I was listening to the other speakers, and this whole confluence of IPR and different domains, especially fashion, is very intriguing. So is the domain of art. It's again although it's a very established business, very established industry across globe, it still is a niche field in terms of law. When am I audible?
Yes,
I
yes.
Sorry, it seems there was
Yes,
some
please
issue.
go ahead.
So if you can see my slide, I've quoted Albert Einstein where he said, "Creativity is intelligence having fun." So when we create something, when we doodle something, or when we just sit with our pen and paper and start making something, it is somewhere our intelligence is coming into play and expressing our idea. And wherever there is intelligence, there has to be intellectual property. And where intellectual property can be protected as an original work, as a novel invention, or as a original design, then it also accrues certain right, which is called intellectual property rights. In arts, we specifically deal with fine arts, we deal with visual arts, we deal with performance art. And under this foundation that we can consider the whole art law domain. People who probably are into art and follow Van Gogh just like me, and would be aware of and would have seen this, would recognize Joseph Rollin, who's in the slide. He was one of the friends of Vincent Van Gogh, And in several times, Vincent has painted Joseph Rollin. A couple of his paintings are in Museum of Fine Arts and Museum of Modern Arts, and it's a very interesting subject. Why I use this slide is this is a phrase which was probably a dialogue from one of his movie Loving Vincent. It says the trick is to know what you're fighting for. So when we talk about IPR in arts, we need to understand what exactly are these rights which an artist or a gallery owner or a museum owner or any artisan has or can assert. In the most important and the most crucial aspect of art is the copyrights. In Copyright Act, if we talk about the Indian Copyright Act, it defines art and artistic work, which can be a painting, which can be a sculpture, which can be a diagram. It can even be work of architecture. And then there are other works which are like performance arts, which probably are not part of the definition of artistic work, but can be protected through, say, dramatic work or some other means. In totality, this construes the whole art, art subject matter of the artwork. When we say what are these rights which are granted to artistic work, then they are right to reproduce the work, right to issue copies, right to translate, right to adapt, right to communicate to public. So these are the exclusive rights which are given to an artist or the owner of the artwork. Now, there is always a confusion between who is the owner of an artwork or who is the author and what happens if the artwork is in public domain. These are issues which always hover around the whole art industry. And by going by the Indian Act, the Indian law, the artist who is an author of the work is the first owner of the artwork. So is in the case of photographer. However, if there is an agreement between the artist, say there is a commission agreement, or there is an agreement with the photographer, in that case, and the agreement allows the assignment at the very moment, then the owner becomes the person who has commissioned that work or asked for the photographs. In art, it's very interesting. Like, well, while dealing with a couple of artists in galleries, there are times when these artists have different mindset and they do not want to come out of that mindset. They do not want to be bounded by laws and they do not want to understand the complications and legalities. And this is a very very a very it's a situation which across the board, which is across the board, and everyone faces this issue. It is That's why it becomes more interesting, because how do you not bind the artist and still get the work protected? That is very important. I'm just giving you an example of how artists have not benefited from their artwork per se, but when it was created or published in a different manner, it could have been commercialized. Again, going back to Van Gogh's example, he created 800 works and he died a pauper. He could only sell one work during his lifetime. So was the case of Rembrandt or Renoir. They all did not make as much money as they could if they were alive today, because their works are auctioned and sold in millions and billions. In this case, Andy Warhol was a pop artist and he created certain artwork of cans. And he created 36 pieces of cans and he was just exhibiting or selling those 36 pieces separately, and people mocked it. They said, there's no art in this, it's absurd. Later, that company of whose the cans were created, Campbell Soup Company, they collated all these cans, 32 in fact, and created a collage of those 32 cans and printed them on paper dresses. As you can see, one of the paper super dress, as they call it, is in the slide. They created a dress and they started using this dress as their promotional and marketing material. They started sending it out to their, to the buyers, and now these dresses have become an epitome of using pop art on fabrics, on apparel. So it has transgressed the art and got into fashion. So that is how art has influenced the other domains. Andy Warhol's Super Dress is a classic example of uh, how pop art has got its presence in today's fashion. You will see a lot of designers working on pop arts and creating amazing dresses. Then, of course, when we understand that there is a lot of potential, a commercial potential in art, there's definitely something always gray would happen. And a lot of times, a lot of artists, they create some really amazing artwork, and which finds its presence and popularity when it is commercialized in certain manner. Christian Dior is also got entrapped in one of the circumstances or situations where Dior's team has used people trees artwork, which was some yoga poses. It would have gone unnoticed, and Christian Dior must have, could have sold several dresses uh, without people tree noticing it. Arijit Sen, he is the artist involved, but it so happened that it got published in the magazine, and it came to his notice, and then the whole issue started, that how a designer of such global fame did not realize that the artwork is someone's original intellectual property right, and copied it intentionally, unintentionally, for whatever reason, but did not give the credit to the artist. Now, when such situation happens, of course, you can always go to the court, get an injunction. But is it always a good idea to go to court, get an injunction, or try for injunction, and have that lengthy litigation process? No, maybe not. If there are other ways to go about it, you can have out of court settlements, you can have mediations, you can have conciliations and negotiations. And one of these things happened between Arijit People's Tree and Christian Dior, and for an undisclosed amount, they settled the matter. When I say piracy is fairest of all, is because when something gets noticed as it is a counterfeit, or is it a copycat, or there's a piracy, then it's always in black and white. We always know it's a piracy. We always know that there is a copying. If I see um, if I see horses made in certain manner, I would say, okay, this is MF Hussain. So there's always piracy. But yes, inspiration is always in gray. So when somebody says that, an artist say that my work has been copied, and the copier says that no, I was also inspired to do something of this nature, and he created an artwork. Then it depends upon whether the copied artwork or the allegedly copied artwork is a substantial imitation. Then we go into the aspects and the test of copyright, which is judgment, skill, and labor test, which was laid down in EBC Modak. So it is always, inspiration is always a subjective term. It does not have an objectivity. It depends upon judgment, skill, labor test. It depends upon substantial limitation. It depends upon sweat of brow. And to prove that, it is all evidentiary. There are situations like, for example, recently we all heard about Badshah's issue with the Bengali music composer and lyricist, the songwriter. And it could have been possible that, you know, that Badshah was not aware of anything of that person, or existence of that person at all, and he would have thought that this work has come from public domain. In those conditions where you are not aware, or something is done unintentional, the law allows you that defense and says that okay, fine, you can go ahead, you will still be injuncted, but you don't have to pay damages. But yes, because of all those media trial and so much hype created by media and in the social media, Badshah considered probably fit to pay certain compensation as well. So when it comes to art, what amounts to plagiarism, what amounts to inspiration is very important. And again, it's a very subjective thing, but it has to qualify the test, which is judgment, skill, and labor test. There are obviously again everything will be done for some commercial interest. So it is important to understand what commercial interest and what can be a protectable subject matter and where you can protect that commercial interest in that matter. It is very important to understand that only original work can be protected. If I create an elephant and some probably Ankita creates an elephant and they look all the same, they look like a regular elephant, there's no originality. But if I create it as a running elephant and she creates a sleeping elephant, then probably they are original work. So you also need to understand that the first groundwork or the basis of any piracy or any inspiration is originality. So whenever you create a work, it is important that you have an evidence of originality. You create also a proof of originality. That is largely about how you deal with the piracy in artwork, in art law. Then art art law is not only restricted, or the rights are not only restricted to intellectual property rights, but also goes into the aspect of moral rights. Although in copyright, we have a completely specific provision of moral rights or author special rights, but it is in a way that it is still not a very developed jurisprudence in India. There's a very famous quote, or I found it very interesting, and that's why I wanted to share with you guys. Is one of the observations of Justice Jaspal Singh, who was a single judge, and when the matter went to DB in Pradeep Nandarajog's judgment in Amarnath Sehgal case, this was quoted, and I would like to read it. In a country rightly proud of its creativity and ingenuity, men who can hardly distinguish the heads of Venus from those of Mars cannot be allowed to decide the fate of artists who create our history and heritage. The cry is "Il ne posson pas," which is no one shall pass. And in such a situation, Indian courts will always be found dynamic and responsive. Now, as I always say, and probably lawyers would and law students would agree, ubi just ibi remedium. So where there is law, there is remedy. There is a law which protects your interest, even if you have assigned your rights to another owner. There is still something called special rights or moral rights, which are associated with you, with your work. So if you are an artist who has been commissioned for a work, and that work is a mural, just like if you can see in the slide, there's a mural which was commissioned by Vigyan Bhavan, by the government, and Mr. Amarnath Sehgal, a celebrated Indian artist, he had created these murals. And and even if these work were owned by Vigyan Bhavan or the government, he still had these special rights with him, that he can claim the authority, he can claim his authorship, he can stop mutilation or destruction of the work, and if something has been mutilated or destroyed, then he can claim damages. So, through this judgment, there was a bit of jurisprudence which was developed in terms of moral rights, and the court held that Mr. Sehgal should be awarded injunction, or he should be given some relief in respect of his murals. Contrary to this judgment, in lately what has happened is that there's another judgment which has came before the Delhi High Court, and litigation came before the Delhi High Court and the learned court, and has passed an order where they did not recognize moral rights in terms of work of architecture. The court made a very distinguishing observation, and also on a very pressing note, said that where the moral rights cannot supersede public rights or eminent domain of using a land. So the court said that because land is very expensive, so if a work of architecture is has been created or authored by an artist and that has to be demolished for use of the land, then that can be allowed, and the artist will not cannot assert any moral right on that. it it's it's again it's very dubious sort of a submission or an observation, because what is going to be its implication that any work uh, or any work of architecture, be it Taj Mahal, be it Humayun's tomb, be it any work of architecture which is a recognized property, which is a heritage site, can be demolished if the government is able to show that the land value is far more and supersedes any rights associated with the artist. It can have various repercussions. This is one of the things that I'm thinking of. And contrary to this proposition, what has happened in India, very interestingly, in the US, there was this case of 5 points wall, where there was this whole complex which was used by graffiti artists, and it became one of the landmarks in the New York City in the Long Island part. And in the US, they have a very specific, similar to our author's special right, they have a similar provision called Visual Artists' Rights Act, VARA, which is 107 USC. Under the VARA Act, under the Visual Artists' Rights Act, the court observed that by demolishing the graffitis, the building owner, has infringed upon the artist's these special rights, moral rights, I could say, in Indian context. And on that count, the court has granted $67 million as compensation. Now, if we replicate the same scenario in India, this could have still have been some solace to the artist, but unfortunately, Indian courts have completely disregarded, uh, compensating the artist and creating a sort of an environment where people start appreciating art. This would have been a completely different situation. We are expecting that the order will be appealed and we'll have better judgments of the court which appreciate art, which appreciate the creativity, the ingenuity, and the labor which goes into creation of these masterpieces. Well, there's a lot which we can discuss in the art law. Perhaps we don't have enough time also. But yes, in a nutshell, art law is a multidisciplinary domain. IP is just one bit of it. You have a lot of insurance involved. You have a lot of estate planning involved, a lot, as in a lot of trust and wills and interstate bequeathing. You have a lot of contracts involved, a lot of probably some white collar crimes like money laundering is involved. So art is a very interesting domain in itself, and we need a lot of lawyers in this domain, because still it is, and to an extent, an unorganized and not very well informed sector. We lawyers can do a very good job in terms of creating that awareness across the domain of artists, gallerists, museums, and we can promote the idea of enjoying art. And probably that is what the whole art law India is about. Ankita, I'm sort of, yeah.
Thank
Do I
you
need to
for
take some?
placing.
Uh,
No, is the presentation complete?
yes, I think I'm done.
Okay,
Yeah, I
okay,
think it's like, yeah.
okay. Thank you for gracing us with such interesting information. It was very insightful to know about art and fashion in such ways. Our final speaker for the session is Ms. Samrita Pahwa, who will speak about intellectual property rights and fashion laws. She's an advocate of intellectual property litigation, advisory and civil dispute resolution, Delhi High Court. She's an alumni of Department of Law, University of Calcutta, and she pursued her master's from National University of Singapore. Ms. Pahwa has recently introduced a new course on fashion laws in the legal world, and she has argued many famous cases like India's first standard essential patent litigation before the Delhi High Court. Welcome, ma'am. You can proceed with your presentation.
Ma'am, please enable your mic and then go ahead.
Yeah. Can you guys hear me now?
Yes, better.
Yeah, go
Okay,
ahead.
great. So, good afternoon, everyone. Thank you for joining in. First, kudos to Legal Desire for organizing such an event. I did listen in to Subhash's presentation, and it was most insightful. And it sort of correlates with what I'm here to talk about, which is fashion law. So, what is fashion law exactly? Fashion law is also called apparel law, right? Let's go about what we're going to speak about today. First of all, we'll discuss what is fashion law, what is the current status of it, how IP and fashion are sort of interdependent. We'll briefly touch upon wearable technology and then finish with a few notable cases. So, what is fashion law exactly? It's fashion law in India is also called apparel law. It's a 14 million trillion dollar industry, and it's, if I can take an example, it's as though if you look at a garment, it's how you would, from the conception of the garment to the sketch of it to when it goes to a karigar, when and then you finally build it up, and then when you sell it to the end consumer. So how you trace the garment from the start to finish, all the legal aspects needed in that is sort of in the fashion law department. Now, fashion law in India is there's no certain umbrella term as fashion law. So there are various ways that we can bifurcate and sort of understand what the importance of it. So what all does it encompass? It entails, most importantly, intellectual property. If you have to understand the business structure, how you want to grow your business, if you want to do any international trade, you need to know about the laws. There's If you have a big enough organization, you need to know about the labor laws. There's a lot of piracy and privacy issues also needed to know, and of course, there's counterfeiting. Now, how established is it in India? I've gotten this question many times before. Actually, the fashion industry is really big in India, but fashion law is actually gaining quite a lot of momentum. There are a lot of organizations. Uh, so I think the video is deactivated. Anyway, I'll go on. So there are a lot of organizations which deal with the research and helping of the designers to grow. Organizations like FFI, FDCI, and APEC. And of course, there is trademark, the laws that they have in the country, which are trademark, copyright, patent, and design, and GI, which help in the protection of the IP. Um, in India, I think the only way we can deal with fashion law and grow in it is if we take inspiration from UK and USA. So even when it comes to litigation, we I think IP is the only place where international precedents are admissible in court. So there are a lot of ways that we take inspiration from UK, US, and EU laws. And there are various ways that we need to sort of implement them in India. Like, for example, I can think of something like utility patent, which will do wonders if it is incorporated in India. Because right now the patent the law that there is in terms of trademark, copyright, and patent, there's so much gray area in it that it gets difficult for an artist or even for a lawyer to sort of fit in and protect in whichever way possible, the best way possible. Okay, so now let's go on to the new dimensions of IP. Although it isn't new, but in my opinion, and whatever little uh, I've worked in the industry, in my opinion, there are three very important factors. One, which is prosecution, which means filing of the IP. Uh, Almost all the time, artists are most confused as to which act under which act should they file their IP. Should it be trademark or copyright or design? And there's most confusion between a design and a copyright. Then there's transactional work, by which I mean agreement drafting. So there is a lot of agreement work, contract work, which comes in the fashion industry, especially when it comes to licensing and assignment and things like that. Then, of course, there's litigation. So anything which goes south can be taken to court. And apart from that, there is your regular trademark, copyright, patent, and design. So we'll quickly go through what these 3, 4 acts tell us to do. A trademark is any representation, word, phrase, symbol, sound, smell that you can protect. Let's go through the examples first. So anything which is, these are your very famous fashion law trademarks. Now, as a practicing lawyer, one would always suggest the client to bifurcate the trademark and then file separately. So the Chanel that you can see, the C should be filed separately, Chanel should be filed separately, and of course, if required, all of it should be filed as one, as a logo, right? When it comes to copyright, copyright is any dramatic, musical, literary, uh, artistic work which Subhash already spoke about, and this any sort of software, which is also sort of confusing part right now. A lot of clients come to me, a software is always copyrighted and not patented. That you must remember. A patent in terms of fashion should constitute these 3 steps, which is very important. It should be novel, which is new. It should be capable of industrial application. So when I invent something, it should be able to be applied to any sort of use in industrial application, and it should obviously should have an inventive step to it. It shouldn't be somebody else's IP or somebody else's patent, which is already in the public domain, and I'm just using it. So let's look at examples which are in the fashion laws. Most famous are clasps, zippers, Velcro. Lingerie plays a very big part in patent law. So there is a lot of shapewear involved. Stonewashed jeans require a certain sort of chemical, which and the process of applying the chemical on the jeans, that is very famous. Now let's go on to design. Now, design is any configuration, pattern, ornament, or composition of lines that you can see on a particular article. Now, as examples, let's talk about these really beautiful shoes and bags that you can see. The Christian Louboutin's boots, Celine's case bag. The way they have been designed and constructed, that is what is protected. And how do you, because it's a 3D version, right? So how do you protect it, like practically speaking? So what a lawyer would do is that he or she would take pictures of the aspects that are required in the particular design and accumulate that and then file it. So you have a 3D product and you ask the lawyer to file it, and that's just not practical enough. Now let's come to something which is sort of new and very upcoming right now, which is wearable technology. So what is wearable technology? It was predominantly associated with clothing, but it is very swiftly gone on to everything from your smartwatches to your Fitbits to smart clothing and head-mounted devices. So everything that you wear and it has a technology embedded in it is wearable technology. Now, how do you protect it? Again, um, you would have to bifurcate each aspect, whatever is innovative to you, and protect it under the required or requisite law. So your logo can be protected under trademark, your technology can be protected under a patent, and so on and so forth. But you have to bifurcate it, unfortunately. And even something which I think should be involved in Indian law is protection on the trade dress, which isn't available right now. But trade dress is a very unique way of protecting something which is a wearable technology. But to briefly sum it up, when you think of a wearable technology, you have to think about three particular things. One is invention rights. Are you creating something which is new, which is novel? Data rights. So, of course, if you want the consumer to wear it, to put it on his or her body, to keep it on, there has to be some information that is going on or transmitting from the consumer to the client and then to a bigger organization. So, how do you protect those data rights? How do you protect your rights? And how do you protect the consumer's rights? These are usually protected by terms and conditions and privacy policy, which are a must, and of course, contracts. And then, of course, there are product rights. How will you bifurcate, like we previously spoke about? How will you bifurcate your product and then protect in the necessary IP that there is? Okay, so now let's discuss a few famous case laws. We'll discuss only 2 or 3 of them. So first is the Starbucks versus Sardar Baksh coffee. It is a very famous trademark case where Starbucks sued Sardar because it was a phonetically similar trademark, and of course Sardar Baksh had to amend this trademark to add a Sardar Baksh G so as to not have being deceptively similar to Starbucks. Now coming to Ritika versus Biba, this is a very critical case that I would think that is that all law students should know about. It's sort of how copyright and design have an overlapping feature. So I'm sure everybody or almost everybody should know that if you have a copyright on a particular article, something like Ritu Kumar had, and if you wish to reproduce that over 50 times. So obviously she was a designer and a designer label. So she had made multiple productions of it and sold it off. And as soon as you hit 50 and above, the copyright stops subsisting in that particular article and then goes on to the design domain. Now, unfortunately for Ritu Kumar, it did not have a design application on that particular article and could not stop Biba from reproducing that particular design or that particular artwork. So that way, it's very important for any designer to know that you must have a copyright and a design application. If not, it's not allowed at the same time, but it can be made after a particular time as well. But you must have it in mind that as soon as this is my agenda, this is what I want to do with my particular artwork, and as soon as that's done, I must file for a design application instantly. Now let's go on to the patent litigation, which I was a part of, which was India's first administrative patent, is quite a technical case. We'll leave that for some other time. But we'll come to another patent litigation which was Spanx versus Yummy Tummy. Excuse me. Here, so Spanx and Yummy Tummy are both shapewear brands. They're something that you wear inside or before your t-shirts and your tops, which is to make your physique look more presentable. So both Spanx and Yummy Tummy had introduced, instead of their lingerie, they introduced shapewear tanks, which was introduced at the similar time. So Yummy Tummy sued Spank, saying that they had infringed the patent and the design. But unfortunately, they had to go on and settle the matter for an undisclosed amount and sort of bury it down. But that led on to a lot, very, very um, aggressive litigation, so to speak. But the very latest one, which I was most curious to read, was about FTC versus TME. So what happened was TME LLC is a company which has an array of teas and solvents, which and they their claims are that they can cure everything from weight gain to cancer. So they have migraine issues, and if you have any sort of issues, it can be cured if you drink one of their teas. Now, what happened was Federal Trade Commission sued TME, saying that these claims that you were making are completely unsubstantiated. There were no tests and clinical trials that were done to have these claims substantiated. So they not only sued TME, but there were many celebrities and Instagram influencers that were advertising or promoting for TME. So FTC sued TME and sent notices to the said Instagram influencers and celebrities. And of course, TME settled the matter for $1 million. But this comes to a very big question that how do you protect so social media promotion is big now, right? And considering COVID times, everybody is on social media. So how do you protect how do influencers protect their rights, and how do companies like these protect their rights? So this is a very interesting area to deal with right now. And fashion law in general also is it's most interesting because you get to read and you get involved with artists, and artists are my favorite kind of clients to work with. But if any student or if any upcoming lawyer wants to get into this field, I would say go for it. But you have to understand that, and I would suggest them to go through the three phases of knowing what is fashion law, which is first, which is prosecution, second, which is litigation, and second, which is transactional, and third, litigation. So these three are very important stages that you must have some sort of experience in, so as to give a holistic suggestion or an advice to your client. And with that, we end my presentation. Thank you for listening. Ankita, are you there?
Hello. Yes, ma'am. Thank you for such insightful information.
My pleasure. Thank you for having me.
It was a delight to have all the speakers. We gained a lot of information about fashion laws, including the importance of fashion laws, trademark and copyright protection, the fashion law industry existing in United States and India. We also learned how art is related to fashion. Thank you, ma'am. Thank you on behalf of Legal Desire for your presence in providing us with an insightful and informative session on fashion law industry on such a short call. Thank you.